All right, we are about a minute in, so I will not delay things any further. My name is Dominica Essie. I'm the CLE and Sections Coordinator here at the Cleveland Metropolitan Bar Association. Thank you for tuning into today's program. If you are here today for CLE credit, you have to do two things. Complete the live poll that will occur during this program. There's just going to be one, and fill out the brief survey that will be sent to you following the program. If you have any questions today, enter them into the Q&A function or the chat, and we will relay those to our speakers today at the end. And with that, I will turn it over to the CMBA's Bar Counsel, Stephanie Anderson, to introduce our speakers today.
Thank you, Dominica. Today we have a really exciting presentation on the current war in Ukraine, and specifically talking about what the world has witnessed with respect to Russia's invasion of the Ukraine and the wartime. I cannot talk today, I'm sorry, the wartime atrocities. So we have with us today Professor David Finnegan and Professor Michael McDaniel from the Western Michigan Law School Thomas M. Cooley School of Law. Professors Finnegan and McDaniel are going to talk about the legal framework for holding Russia accountable, and how we can hold their political leaders legally accountable for the war crimes that are being committed. With that, I will turn it over to Professors Finnegan and McDaniel. Thank you again.
All right, thank you. I will start us off here. Let me share my screen. I'm going to use a few slides to help organize the presentation. So can everybody see the slides?
Looks good.
Okay. Well, my name is Dave Finnegan, and along with General Michael McDaniel, we are professors of law at Western Michigan University Cooley Law School in Lansing, Michigan. And let me begin by thanking Stephanie Anderson and the Cleveland Metropolitan Bar Association and its staff for hosting us here today. As Stephanie indicated, we've seen almost daily in the media reports of atrocities taking place on the ground in Ukraine in connection with Russia's unprovoked invasion. And so today we're going to talk about what we've been seeing on the ground in Ukraine and relate it to the international legal framework that governs or addresses wartime atrocities. I'm going to begin by providing a big picture overview of that legal framework. And then General McDaniel is going to bring us up to date on some of the things that unfortunately we've seen happening on the ground in Ukraine and suggest how the legal framework may apply to some of those atrocities. And so I'm going to focus my comments, and I'm going to kind of move my slide up here. I'm going to focus my comments on three short points. First, as I said, just provide a big picture overview of the applicable legal framework that allows us to sort of think about war crimes and bringing perpetrators to justice. And then I want to highlight briefly a few challenges that I see in that regard. An immediate challenge, a short-term challenge of making sure that we as a world community can gather and preserve evidence of war crimes so that down the road, when prosecutions take place, those prosecutions can be effective. And then a longer term challenge is, I think, the question of how we should go about prosecuting those war crimes. What is the appropriate forum? How should the machinery of justice work itself out here? So first, let me talk about the legal framework. And I think it would be helpful to begin by noting that when it comes to international law, the international legal system is relevant here on two levels. And let me sort of describe what I mean by that. How do we bring Russia to account? How do we bring individual perpetrators of war crimes to account? And in thinking about international legal responsibility, there's really two levels here. We can think about, on the one hand, the nation state and holding nation states responsible for committing wrongful acts. But at the same time, we can think about another level, and that's the level of the individual, and holding individual criminal defendants responsible for wartime atrocities. International law, historically, is a body of law and related legal institutions that is primarily targeted at nation states. It is a body of law primarily intended to regulate international relations, to regulate the behavior of states as they go about interacting with each other in the international arena. And a primary goal of international law is to help maintain peace. And in the event that disputes do arise over time between or among states, that those disputes, we want to maximize the chances that those disputes will be resolved peaceably. After all, nation states as actors have militaries. And so there are tragic consequences that can result from other than a peaceful resolution of disputes. One bedrock principle of public international law is the prohibition on the aggressive use of force. And that prohibition is most famously enshrined in the United Nations Charter, the treaty created at the end of World War II that established the United Nations system. And Article 2, subsection 4 of the UN Charter expressly prohibits the use of military force by states against the territorial integrity or political independence of other states. And in my view, there's no question here that Russia, in initiating this unprovoked invasion of Ukraine, has violated this fundamental prohibition of international law. And we saw almost immediately after the invasion started, the world community officially declaring the invasion illegal. And let me just highlight two examples of these declarations of illegality. On March 2nd, the United Nations General Assembly adopted a resolution titled Aggression Against Ukraine, declaring Russia's invasion a violation of Article 2.4 of the UN Charter. Over 141 countries voted in favor of the resolution, and significantly, only 5 countries voted against it. And among those 5 were Russia, Belarus, North Korea, and Syria. It just kind of shows you the company that Russia is keeping these days. A few weeks later, we saw a judicial declaration of illegality. The International Court of Justice, the World Court, the judicial arm of the United Nations, issued an order in response to a claim brought before it by Ukraine, requiring Russia to immediately suspend its military activities in Ukraine as violative of international law. The court highlighted in its order the tragic consequences for the invasion on the civilian population of Ukraine: civilian deaths, injuries, destruction of civilian infrastructure, the impact that the invasion was having on civilian access to food, water, medical supplies. Unfortunately, in the real world, armed conflict sometimes does break out. And when it does, international law then attempts to regulate how states may go about deploying and using armed force by limiting its use, defining what counts as a legitimate target, prohibiting the use of certain types of weapons. And this body of law has traditionally been referred to as the law of war or international humanitarian law. And a prominent example in the post-World War II era of IHL are the 1949 Geneva Conventions, which attempt, among other things, to protect civilian populations and prisoners of war during international armed conflicts. And so nation states can be found responsible for having violated international legal prohibitions. But there's another level here, and this is the level that I want to kind of focus my remarks on here today, and that's at the individual level. under what circumstances will individuals be held legally responsible for having violated the prohibitions of international law? And I would say that here our focus is on international criminal law. Can individuals be found responsible for violating international criminal law? And the best example of the current state of international criminal law is a treaty called the Rome Statute. The Rome Statute was opened for signature in 1998. It entered into force in 2002. This treaty both created a standalone court, the International Criminal Court, to prosecute international crimes, but then also defined and described the elements of crimes that may be prosecuted before the court. There are 123 countries that are currently parties to the Rome Statute and therefore members of the International Criminal Court. Unfortunately, Russia is not a party to the Rome Statute. Neither, by the way, is China or the United States, but nonetheless, the Rome Statute provides kind of the building blocks for contemporary international criminal law. And so let me summarize briefly the types of crimes that may be prosecuted under international law. And I'm just going to sort of refer to the 4 categories of crimes that are identified in the Rome Statute. So one category of crimes that is very much relevant to what we're seeing in Ukraine is the category of war crimes. And there's a specific article, Article 8 of the Rome Statute, which identifies war crimes. These are crimes that take place during an armed conflict. Examples include intentionally attacking civilians or civilian assets, executing or engaging in extrajudicial killings of civilians or prisoners of war, torture, rape and sexual violence, the destruction of civilian property or the seizure of civilian property. You know, we've seen over the past months reported in the popular media instances of this type of conduct on the part of invading Russian troops. There's another category of crimes referred to as crimes against humanity. And these are crimes that may take place either during war or times of armed conflict or otherwise during times of peace. And these are crimes that involve a widespread or systematic attack against civilians, where those attacks are part of a government plan or policy. And so if you have this organized government-supported effort to intentionally attack civilians, these fall into the category of crimes against humanity. And examples of this include murder, rape, torture, forced disappearances. And again, although there's a lot of overlap here with what would count as a war crime, we've seen reported in the media examples of this taking place in Ukraine. A third crime identified in the Rome Statute that is relevant or potentially relevant to what we're seeing in Ukraine is the crime of genocide. And there's been some talk both in the media and in diplomatic circles about genocide and the prospect for genocide taking place in Ukraine. President Biden once referred to what we're seeing in Ukraine as genocide. President Zelensky, the president of Ukraine, has several times discussed genocide in connection with the Russian invasion. But I think we have to be careful here because genocide has a very specific legal definition. Genocide involves wrongful acts like murder or destruction of property, etc., but accompanied with an intent to destroy a particular national, ethnic, racial, or religious group. And without that intent, although we may have a criminal act, the criminal act does not necessarily rise to the level of genocide. So the question, I think, for Ukraine is in targeting civilian assets and infrastructure, in targeting culturally significant sites, heritage sites. Is the Russian invasion intended to eradicate Ukrainian culture or cultural identity? And the more evidence that can be accumulated bearing on that question, the more successful a prosecution for genocide might be down the road. A final crime that is identified in the Rome Statute is the crime of aggression. And this is a relatively late addition to the Rome Statute. Prosecutions for the crime of aggression only became effective as of 2018. And so there was a 2-decade period of negotiations before this crime was added to the statute. Aggression is a crime that is targeted at the senior political and military leadership of a country. It applies to, quote, a person in a position effectively to exercise control over and to direct political or military action of a state. A political leader commits the crime of aggression when he or she initiates an act of aggression, which constitutes a manifest violation of the UN Charter, for example, by invading or ordering the invasion of another country. And this was the crime that was prosecuted against the Nazi leadership during the Nuremberg trials at the end of World War II, the International Military Tribunal. And at the end of the tribunal's judgment from 1946 in those trials, here's what the tribunal said about the crime of aggression. Quote, to initiate a war of aggression is not only an international crime, it is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the whole. Without this initial act of aggression, you don't get the other war crimes that may result. Prosecuting the crime of aggression, though, in connection with what we're seeing in Ukraine is problematic, and in my view, unlikely to occur for a couple of reasons. One, the Rome Statute only permits the prosecution of the crime of aggression against individuals who are citizens, the political or military leaders of a country that is signed on to the Rome Statute. Because Russia has not signed on to the Rome Statute, the International Criminal Court cannot be used as a venue for prosecuting the crime of aggression against Vladimir Putin or other senior Russian political or military leaders. And I think that that's one stumbling block that I'll comment on in a few minutes, a little bit more. In addition, prosecutions cannot take place before the International Criminal Court via trials in absentia. In other words, the criminal defendant, the perpetrator, must be physically apprehended and brought before the court to personally appear before the court. And unless, as a result, Vladimir Putin or other senior leaders were to be arrested, I think that sort of prosecution is a non-starter in any event. Okay, but there are some additional challenges in pursuing war crimes claims in connection with what we're seeing happening in Ukraine. And let me just wrap things up here by offering a few remarks on those challenges. One is a shorter term challenge, and that is the challenge of documenting war crimes, proving that war crimes have taken place, collecting and preserving evidence. And I think that's the short-term or immediate challenge. And what we're seeing is overlapping efforts, both at the domestic level within Ukraine and at the international level to do just that. And let me just highlight a few of these efforts. One effort to investigate and document war crimes is taking place at the domestic level within Ukraine. The activities of Ukrainian law enforcement officials, primarily Ukraine's Prosecutor General's office. As of mid-May, that office had opened over 11,000 separate investigations of war crimes. And the office has already identified 40 individual suspects, perpetrators. And we saw earlier this week the conclusion of the first domestic war crimes trial that resulted in the conviction and sentencing of a Russian soldier. But in parallel to what is happening on the ground domestically, we're also seeing international efforts to document war crimes. And I would say the most notable effort is the team of investigators that was recently inserted into Ukraine under the auspices of the International Criminal Court's prosecutor's office. After Russia began the invasion at the end of February, over 43 countries around the world referred the Ukraine crisis to the ICC prosecutor's office. And the prosecutor, Karim Khan, opened up an investigation into war crimes, crimes against humanity, and genocide in Ukraine. And just last week, the ICC sent a team of over 40 investigators, forensic experts, and support personnel to Ukraine in coordination with Ukrainian authorities. And various countries have contributed personnel to that team, most notably the Netherlands. And Prosecutor Khan has consistently emphasized the importance of coordinating efforts with Ukrainian authorities and other international teams. For example, the ICC team is already coordinating efforts with a team of French forensic experts that are on the ground in Ukraine. To date, 21 states have volunteered to contribute national experts to the ICC team, and another 20 or so states have publicly committed to providing financial support to these investigative efforts. Notably, the United States, although it is not a party to the Rome Statute and so does not participate in the International Criminal Court, has publicly voiced support for the work of the ICC and the prosecutor's office here, in particular through the voice of the U.S. Ambassador at Large for Global Criminal Justice, Beth Van Schack. There are other international human rights organizations that are also sending teams into the country. One that I just wanted to highlight is the Human Rights Monitoring Mission in Ukraine that was inserted by the United Nations in 2014 following Russia's annexation of Crimea. As of a few years ago, that team had more than 60 staff members on the ground. And within the last week, that mission has come out and indicated that it has documented over 3,000 instances of civilian deaths in Ukraine and about that many of civilian injuries, although the numbers are believed to be much, much higher than what the mission has been able to document up to this point. That same mission has also been able to document and confirm over 120 cases of arbitrary detentions or forced disappearances of civilians. And so you have these overlapping efforts to collect this evidence. And I think ultimately, preserving that evidence, ensuring proper chain of custody is going to be important when it comes time later to assemble effective prosecutions for war crimes. Finally, I want to say something about the mechanism for holding war crimes trials. What is that going to look like? And I think the longer term challenge is for Ukraine in collaboration with the world community to settle on a mechanism for bringing individuals to justice, war criminals to justice, that's going to be effective. Effective both in terms of international political legitimacy, but also effective from the standpoint of the law. The International Criminal Court stands at the ready as a pre-existing institution with a set of judges, a prosecutor's office, teams of investigators. It's up and running, based in The Hague in the Netherlands. And so that might be a kind of a natural mechanism. But as I suggested a few moments ago, there are some limitations involved there. And so there's been some debate among international lawyers and diplomats about maybe pursuing other options for holding a war crimes trial based on some of the past examples. And here are just, this is the last slide that I'll show, some of the historic past examples of what I would consider successful war crimes prosecutions. Of course, we saw the Nuremberg trials at the end of World War II. I've already mentioned those. In the 1990s, the UN Security Council helped to create two standalone international criminal tribunals, one to investigate war crimes and genocide that took place during the Balkans War in the former Yugoslavia in the 1990s, another to investigate the crime of genocide that took place in Rwanda in 1994. Those two tribunals really advanced the ball significantly in terms of shaping what exists today as international criminal law. And then more recently, you have these hybrid tribunals, one created to address war crimes in Sierra Leone and Liberia. That special court most famously successfully prosecuted Charles Taylor, the former president of Liberia, for crimes committed during that conflict. And then we also have a hybrid court recently created with the participation of the United Nations to prosecute claims of genocide in Cambodia taking place during the Khmer Rouge era in the 1970s. Each of these mechanisms, in my view, is problematic on certain levels. Each has some strengths and weaknesses. But I guess the point that I would like to leave you with is that I think the world community is going to become involved increasingly in a vocal debate over the coming months as to the forum that is best positioned to prosecute war crimes, bring these perpetrators to justice. Okay, so let me wrap things up there, and I will turn things over to General McDaniel to talk a little bit more about what we're seeing on the ground in Ukraine. And let me stop sharing my slides here if I can.
You are muted, Professor McDaniel.
Thank you, Stephanie. All right, good afternoon, everyone. Sorry about that. I've only got a few slides as well because we want to sort of focus in on just a couple of issues here. The first I want to note is that it's been almost exactly 90 days, February 24th, when we had something unparalleled in terms of international activity, a special scale, at least since World War II, with the invasion of the sovereign country, sovereign state of Ukraine by its northern and eastern neighbor, Russia. And so I want to spend just a couple of minutes of thinking about, first and foremost, how's the war going? Well, it's not going well. Our special military operation, as Russian leaders would say, it's not going well. If their strategic goal was to expand Russian territory, and I think it was, and for two reasons. First is the need for natural resources. Ukraine was always the breadbasket of the Soviet Union and was focused on as such by Stalin. And its resources aren't just agricultural. There's mineral rights, oil and gas, natural gas that are really important there as well. And then the other reason is sort of to have a buffer as well. This was sort of noted by Russian leaders, particularly Putin, by saying that he wanted to recreate the Russian empire. Some have laughingly called it the Soviet reunion. The Soviet Union. I think there is a little truth to that, though. But the real reason is not so much this ensuring his legacy, though I'm sure that's part of it, but it's really this idea of creating a balance of power. there was 14 republics besides Russia, and many of those are firmly in NATO. So I think that when George W. Bush insisted that that Ukraine had to be on the path to NATO membership, that at that time, that was a trigger for Russia, rightly or wrongly. If you're looking at how this is going, then strategically, obviously, it's going poorly. It has the opposite effect. It is further isolating Russia, and secondly, it's increasing the size of NATO. If we look at how it's going operationally, their first operational goal, which was to capture the capital city and military and political leadership so that they could control the rest of the country. They've also failed at that. They tried a blitzkrieg approach, and the Ukrainian defense forces stunned the world by denying them Hostomel Airport without air superiority or the ability to move troops and equipment easily. They were stuck in a long line. We saw pictures of this 40-mile convoy that had, I am sure, many military leaders, and particularly on the air side, wishing for an opportunity to attack and wipe out those troops. Cooler heads prevailed on that. We stayed out of that conflict at that point of time. Ukraine prevailed, pushed them back, denied them not just the airport on the first 2 days of rather vigorous fighting, but denied them the capital of Kiev and surrounding areas. So they have refocused on on the eastern and southern portions of Ukraine, looking to consolidate their holdings around the Donbass region and in Crimea, as you can see in these two maps. This fighting has been referred to by the media recently as a stalemate or a quagmire. Two different topics, but let's just say I don't believe it's a stalemate. A stalemate is a really dangerous word to use because it suggests that things are going to be bogged down for years, and that therefore the U.S. can get off the ball. Western allies can stop supporting Ukraine, and that's absolutely the wrong thing to do for a number of reasons. First is, just as we see this as a conventional war for the first time in quite a while, and therefore military experts and students at Army War College and otherwise are looking at this and saying, we need to focus on this, because everything we learned we never got to use in an age of asymmetric warfare. But the same is also true, as Professor Finnegan said, with the new era of international humanitarian law. This is an opportunity for principles to be reasserted and to be reasserted across Europe and worldwide that perhaps have been done in a rather creaky or old-fashioned or sort of almost spontaneous fashion, reacting to certain conflicts that we've seen in the past, as he outlined, such as in Sierra Leone, Yugoslavia, and Rwanda. It's an opportunity for the world to sort of debate these. And so I just want to take a few minutes of your time today and sort of talk about what we've seen with some examples in Ukraine by Russian forces, particularly those that have been in the news the most. But I want to talk about them in context. And in doing so, I'm going to sort of talk about them under the principles of international humanitarian law. So Professor Finnegan sort of listed the treaties there. And if you think about it as law school, then, that's the code, that's the written law. And then there's the common law. The Geneva Conventions really started back in the 1845 or so when they had the first code. And then President Lincoln had invited, during the Civil War, Professor Lieber to sort of create what became known as the Lincoln Code, sort of the first use of rules of war or the law of war by U.S. military forces was by the Union Army in a very focused way, in a codified way during the Civil War. And from that time, and even from ancient time, candidly, these principles have come forward. And those are sort of the principles I want us to focus on as we go forward today. The idea of military necessity, Lieber actually said that the best when he said that the military may use any force that is necessary, but the force has to be controlled. So it's the force necessary to achieve the submission of the enemy. It can be overwhelming force, and that should be overwhelming force because you want to subdue your opponent as quickly as possible and prevent further suffering either to the other military troops by prolongation and certainly to the civilian population in that area and civilian infrastructure as well. Humanity is sort of this idea of avoiding unnecessary suffering. It applies to both your opposing forces, and it certainly applies to POWs, which gave rise to the Geneva Conventions that we saw after World War II, and it certainly applies to civilian populations as well. So humanity and distinction sort of go hand in hand, and distinction is the idea we're looking at combatants and we're treating them in one way. And then and everyone else should be treated differently. Now, everyone else, it sounds sort of glib or superficial for me to say that because there's so many different categories that we recognize under international law, but not so much. The idea is combatants, everyone else, and whether we're talking about whether we're civilians, whether we're talking about the wounded and injured, we have to sort of treat them as different from combatants, and that is often lost and is a key point there. So with that rather quick fire introduction, I want to look at a couple of examples that we've seen. The idea of hors de combat is a very strong principle based upon those previous principles that we saw. If you are no longer a combatant, you cannot be treated as a combatant. I saw this in, I think it was the Washington Post, or just today. They had a lengthy article about some Ukrainian combatants. They weren't, they were militia. They were not members of the Ukrainian Defense Force per se. But remember that the Ukrainian president has said that every male should remain in the country and support the effort to repel the invasion by the Russians. So there was 9 individuals in Bucha who are in one building, and they are all militia type combatants, and they had like 1 grenade and 1 pistol and 1 rifle among the 9 of them. So they're hiding until they are totally surrounded, and they are forced to surrender. Once they are discovered by Russian paratroopers, they are taken out of the building. They're marched down the street to an alley, put up against the wall, and they're all shot and killed, except for one who managed to, play dead, so to speak, after he was shot and injured. So there were civilians, obviously, that were able to take small portions of this, that see them going down the street, see them being moved, and there's the testimony from at least one of the individuals. This I use this as an example, not because it's so current. It just sort of happened today, or was reported at length today, happened as they were leaving Bucha. But it gives you an idea of some of the nuances here. So these are not organized military forces. They are not members of the Ukrainian Defense Force, as I said. But the rules are that if you are militia forces, you are sort of this levy en masse that rises up against the invading force. You have to comply with 4 characteristics to be considered a legitimate combatant. You have to be carrying weapons openly, which these individuals were doing. You have to be part of a unit with the leader, which these individuals sort of had. Obviously, the 9 of them hiding in this basement couldn't be said to have a full structure. They were carrying or had patches which distinguished them as members of this allied force of armed civilians. And the fourth one is that you have to sort of follow the rules of international humanitarian law yourself, which don't know at that point. But the two that are usually the most relied upon or the most important for analysis are the fact that they are acting in they have some distinctive sign or badge or insignia indicating that they were members of a force and that they were carrying weapons openly, which clearly applied here. I go through that only, as I said, because there are a lot of forces there who are engaged, and as we've seen in many conflicts in the last 20 to 30 years, it's difficult to distinguish between combatants, say, and terrorists. Going back, I should actually say, to Vietnam, with the ability of the Viet Cong to fade back into villages and civilian populations, causing disruptions and law of war violations on both sides. So we saw here these individuals who are clearly subject to reprisals. Remember, there is the video footage shows that they were paratroopers, and the two sort of units spearheading the invasion towards Kyiv and got stuck in Bucha were both air assault or airborne or paratroop type units. And this seems like this was reprisals as they are pulling back out of there. Another situation that we see has been a number of mayors, civilian political leaders have been kidnapped or murdered. And in the somewhat gruesome picture on the left there, you can see a woman in this mass grave on the left. Her name is Olga Sukhenko, and she was the mayor of a very small town outside of Kyiv. And she and her husband and child were all abducted, murdered in a mass grave. The use of force against deadly force is obviously against civilians. It is violation of everything, starting with most specifically Article 51 of the additional protocol. Article 51 of Additional Protocol 1 from 1977. It's also obviously violates the idea of distinction between combatants and non-combatants, that issue that we saw with the militia troops in the last one, where they were armed combatants until the point at which they were disarmed, captured, and then became prisoners of war and should have been treated as such. In this case, though, we're seeing a lot of hostage taking, not just of political leaders, but by others. Article 34 of the Fourth Convention, Article 75 of Additional Protocol 1, Additional Protocol 1 focused on international armed conflict and the treatment of civilians during international armed conflict, specifically talks about detention of civilians. Short-term internment is considered lawful. Kidnapping or using as human shields or long-term prolonged detention or harm, of course, is a violation. Again, nuance to be seen here. Even in the idea of unlawful weapons, we're seeing sort of these sort of nuances. We've got sort of two weapons at Bucha that were discussed in the media at some length. So we have a specific, a fairly specific convention against the use of incendiary devices. The convention of October 10 October 1980 is called the Prohibitions or Restrictions on the Use of Certain Conventional Weapons which may be deemed to be excessively injurious or to have indiscriminate effects. A rather long title, but it includes landmines, the part that gets the most attention from that, but it also includes incendiary devices. And I use this graphic, I think it's from CNN on the left there, because there was some talk about the use of thermobaric weapons. These are not considered illegal or unlawful to be used against enemy troops. It is, when the U.S. talked about the mother of all bombs being used, and then Russia said they built the father of all bombs. It is this huge created explosion. As you can sort of see here, it's fired from a missile, and these rocket launchers that fire these particular missiles are on a platform of a T-72 tank. So it's very distinctive to see these and to find these in Ukraine. And Russia has finally admitted that they have used these. But what happens, you shoot this missile, and either through a timer or through detonation on impact, you have this huge cloud of fuel, which you can see in the bottom left, which ignites, creating this big, you create this big mist of fuel, which is then ignited by a secondary explosion, creating this huge fireball. It's also called a vacuum bomb because obviously it takes all the oxygen out of the entire area there. So if you have enemy troops, which are hidden in urban warfare, are often hidden in created bunkers, basements. We used to see it in caves in Afghanistan. Then this vacuum is going to kill them either through this huge incendiary blast, or it is going to kill them through taking all the oxygen out of the room. So if this is being used against civilians, it's obviously an unlawful weapon. As I said, the protocols, additional protocol 1 and others dealing with going back to the very beginning, used against civilian. And that is the problem with their use in an urban warfare environment. If it is being used against military targets, it is not considered to be an unlawful weapon, even though its means of providing kinetic energy against the enemy that is killing them is still horrific. Same with the question of cluster bombs. Cluster bombs have a couple of issues with them. First is that they become widely dispersed, very small little bomblets, as you can see within this tube here in this picture on the right, widely dispersed. And as a result of that, are not going to stay in a limited area if you're in an urban environment. They also have a history of failure to detonate. And some studies show that only 50% will detonate when expected to. So very difficult weapon to use and not have civilian casualties. And as a result of that, there's a convention on cluster bombs. Russia is not a signatory to that. And then the last issue I want to talk about, because it's come up a lot, is the idea of command responsibility. So everybody talks about the Yamashita case as if it was the beginning when this happened in 1945. And that's the picture of the courtroom where Yamashita was tried. I know it looks like Nuremberg, but remember, it's the same era. But it has ancient vintage, because it is the idea that, and it's now been codified in the Rome Statute, which Professor Finnegan mentioned. It's the idea about the responsibility of the commanders. And in a nutshell, it sort of includes, remember, crime of aggression, as Professor Finnegan indicated, is sort of a crime of commission. And command responsibility can be sort of a crime of omission. If you have jurisdiction over Putin, it would be easier to prove if you had jurisdiction over him, which is a totally separate issue. But basically what you have to have is that the superior military officer, including the commander in chief, knew or consciously, intentionally disregarded information clearly indicated that subordinates were engaged in war crimes. And, the forces were within their control. And therefore the crimes committed by those forces were in their control. And then the superior, either ahead of time or after, failed to take necessary and reasonable measures within his power to prevent or suppress their commission, or to turn them over for punishment. So again, it sort of goes right to the idea of a crime of omission. And in this case, we have lots of instances that that President Putin is quite aware of the war crimes. The unit that I mentioned in Bucha received a special award after they retreated from Bucha. It's been in the news, and it's the equivalent of it's the Russian equivalent of fake news, being made up by the West. The military leader now, who was appointed after firing of other military leaders, who is now leading the efforts in the Donbass region, was the leader of the efforts in Syria when we had similar use of thermobaric weapons against civilians and barrel bombs, and as well as murder and raping and looting of civilians. And he was praised by Putin as well, and given the order of, I forgot if it was the hero of the Soviet, a hero of Russia or which one, he was given a medal. So there's clear evidence then of Putin's involvement, to the degree that he has accepted and sort of endorsed or validated these activities, at least after the fact, if not prior thereto. And considering that the Russian military tactics in Chechnya, Syria, and now Ukraine are almost identical now, it seems very likely that he's been endorsing this type of activity all along. Could be responsible as the commander-in-chief, should he be subjected to jurisdiction. Again, I want to stop so we've got time for question. I know that both of us sort of raced through this in the short time that we have, and we thank you for spending our lunch hour with us, considering these issues, and we're open to take any questions.
If anyone has any questions, you can put them into the Q&A function or go ahead and type them into the chat. I am not seeing any as of this point. Now, I have a quick question for you guys, and it's not necessarily on military force, but how successful do you believe that international sanctions have been in curtailing Russia's violence against Ukraine?
I'll go first, and I'll let Professor Finnegan sort of give you the more full answer. There have been instances in the past, but with smaller countries, when the country has been isolated, that the country has risen up against their leader and sort of, by taking him out of power, made him available to international jurisdiction. That it is often a very long process for that to happen. But I think that without looking at individual sanctions, I think that the isolation of Russia, where it is limited to a handful of countries now, has been very helpful. There are many countries, clearly, Stephanie, that are quiet and maybe acquiescing in Russia's behavior because they're so dependent upon them economically. The value of the ruble has not really dropped yet, so there are still a number of issues on whether the sanctions are as effective as they could be. David?
Yeah, I think that's right. I would only add that I think sanctions are one component of a global response that is largely intended to isolate Russia. Because I think that by isolating Russia and its political leadership, the oligarchs that are widely discussed in the media, that might push Russia to a negotiated settlement of the conflict. And I also think that it separately is a reflection of the global effort to hold Russia accountable. And I think accountability, I would say the most important thing is to resolve the conflict, to end the suffering, to prevent these atrocities from continuing to unfold. But beyond that, I think there's a goal of accountability, because looking forward to the future, I think the global community needs to send a signal that there's a certain type of conduct that is acceptable, and there is conduct that crosses the line. Sanctions are part of a larger effort to steer the course in that direction.
Excellent, thank you. Now, one of the questions was, in any situation, how do you assess the chances of sanctions being imposed? How is that assessed?
Well, it is candidly a matter of the degree to which a country is willing to change its behavior. It's not enough to show that sanctions are having economic harm or providing a detriment. A number of countries, and I think Russia was in the same position, thinking that it could survive whatever sanctions Europe, Western countries would place upon it, because they have a substantial treasury. They had a pocketbook ready for war, and I think that they believed that they would be able to withstand the sanctions. The sanctions have continued to be ratcheted up, which also suggests that they have not yet worked. So there's that. And it's the degree to which, as I sort of cautioned, we can't treat this as a stalemate, and therefore it's going to go on. And just as there have been Russian troops in Crimea, there are Russian troops in Georgia, there are Russian troops in the Moldova border region, we should just take that as a status quo. This is a definitely, whether it will be proved a crime of aggression, that will be replicated if Russia doesn't feel the pain strongly enough. And I don't think we're there yet.
Thank you. Now, what about statute of limitations? Is there a statute of limitations on the prosecution of war crimes?
I mean, on the most egregious crimes, typically the answer is no. But I would say that that's one of the reasons why the immediate challenge is to document instances of war crimes and to preserve that evidence, so that the world community can quickly pivot to bringing these claims before the appropriate tribunal. When you think about the International Criminal Tribunals for former Yugoslavia in Rwanda, there were prosecutions going on before those tribunals more than a decade after the events took place. So my sense is that the world community is mobilized is very much engaged with the Ukrainian situation. So I doubt whether it's going to take a significant amount of time once the crisis is resolved to start putting together the machinery of justice to bring these claims.
And you even see that with the International Criminal Tribunal for the former Yugoslavia. Those prosecutions were going on as well long after the crisis had ended. Now, what is the effect of a war crimes conviction on Putin if you can't really enforce it, right? So like in order to, like you said, you can't do a prosecution in absentia. So how do you get him? How can you prosecute Putin for war crimes?
Yeah, I mean, I think that there are practical challenges. So one option that's being debated in the world community is when it comes to the crime of aggression and holding Russian political and military higher-ups criminally responsible, that maybe we should, as a world community, establish a standalone tribunal with the sole purpose of bringing those charges. But even that approach is fraught with some challenges. And let me just sort of highlight two. One is a problem of legitimacy. So the fewer countries in the world that get together and to create one of these tribunals, the less legitimate that effort is going to be. Yeah, if you have universal participation, universal condemnation, but in some of these resolutions that have been voted on at the General Assembly, there are a number of countries, including a majority of African states, that have abstained from voting. Well, if those countries don't end up participating in a global effort to create a standalone tribunal, how legitimate is that tribunal going to be? I see the comment in the chat about people who live in glass houses. That raises a legitimacy question. Another potential problem, very quickly, is a kind of a Nuremberg-style standalone tribunal might be viewed as an attempt to pool together the domestic jurisdictions of all of the states that are participating. And in a pooled jurisdiction model, heads of state may end up enjoying immunity from prosecution as a matter of international law. And so there's also this immunities problem. And these are challenges that the world community is going to have to debate and resolve before we even get to, well, what does it mean to try Putin in absentia if we can't get our clutches on the guy and drag him before a court? So those are just a few brief thoughts on that question.
And what about the preparation of an international indictment? Do you believe that would have any effect in bringing Putin to justice?
Well, I think bringing an indictment and following through with a trial, even if it's in absentia, is one small and maybe an important component to the larger accountability question. In order for an indictment to be formed, rules are going to have to be put in place. Now, the International Criminal Court has the Rome Statute, and there are very detailed rules for how the prosecutor's office goes about investigating and deciding to bring a claim. If we're talking about a standalone or an ad hoc tribunal, there would have to be put in place beforehand a statute or treaty or international agreement that would frame the rules for putting together an indictment. And we're far from that, I would say, when it comes to an ad hoc type approach.
One of the things that David and Professor Finnegan and I have discussed as well, Stephanie, in the past is, could the General Assembly of the United Nations act in some way that would create more legitimacy or more among the international community and therefore more isolation for Russia itself? It is very questionable whether they have the authority under the treaty to create courts themselves, unlike the Security Council. And we know the Security Council won't act, of course, because Russia has veto authority as one of the 5 permanent members there. But there is at least a strong signal being sent by the international community should the General Assembly petition or suggest that a international court be created. As Professor Finnegan says, it takes a treaty to do so and to have the jurisdiction and legitimacy necessary, but it seems to be it would be worthwhile.
Now, so Russia initially signed the Rome Convention, right, but did not ratify it. So does the ICC even have the jurisdiction over Russia?
Well, yes and no. So although Russia is not bound by the Rome Statute, Ukraine, which also is not bound by the Rome Statute, has given its consent to the International Criminal Court to investigate alleged war crimes that take place on the territory of Ukraine. And that is sufficient as a matter of the Rome Statute to authorize prosecutions for those crimes. On the other hand, as we've discussed, given the jurisdictional requirements of the Rome Statute, it's impossible to bring a claim against Vladimir Putin or other Russian political and military leaders for the crime of aggression, because given that Russia has not ratified the statute, that crime may not be prosecuted against citizens of Russia. So I would say that there is the prospect for successful criminal prosecutions against Russian actors while on the territory of Ukraine committing criminal acts on the territory of Ukraine. Now, one sort of final wrinkle here is that do we put at risk the credibility of these efforts to hold individuals criminally responsible if we have multiple and overlapping courts or tribunals involved here? So that, we want the ICC to do some of the work, but we should create an ad hoc tribunal to go after the political leadership of Russia. Does pursuing separate tracks, however well coordinated, undercut the credibility of the global effort? Maybe yes, maybe no, but that is also a part of the debate that's currently taking place in diplomatic circles around the world.
So our final two questions that we have kind of go hand in hand, but from varying perspectives, right? The first being, should we trade immunity for peace? But the second one is it fair to say that the world order cannot allow what Putin and Russia is doing to stand without some kind of legal response? So in effect, on the one hand, we're saying we'll allow you to go, just stop the violence, right? But on the flip side, can the world trust that their country will be safe from something along these lines if we don't hold Putin to account?
I'll go first just to sort of give you from a more strategic objective. There were sanctions that were pretty much a slap on the wrist against Russia for both Chechnya, the second war. They got their butts kicked in the first one, and the second one was after Putin was in power. And then certainly in Syria, it was a lot of hand-wringing, but not a lot of sanctions that had any real metal behind them, any force behind them. And as a result of that, I think there was a perception and analysis by Russian leadership that the world will wring their hands, clutch their pearls, but they won't take any real action. So number one, I believe that we should not be encouraging Ukraine to either a ceasefire or ceding territory for peace. And secondly, I don't believe that we can trade immunity for peace either. I think that will be seen as a very, very no-brainer, easy deal for Russian leadership, and that will not stop them from doing it again, whether it's in Moldova or one of the, say, Baltic states or countries that are, even countries that are in NATO. So I don't think that we can do that. We have to have some sort of firm response to this aggression, whether or not we can convict them of aggression. We have to have a strong international response to it.
Anything you want to add, Professor Finnegan?
Just one quick comment. I think kind of embedded in the premise to your question is something that General McDaniel had referred to during his presentation, and that is, a lot of these international norms, international humanitarian law, the principle of distinction, protecting prisoners of war and civilians, these are longstanding principles. What the world community is called upon to do today is to think about how these venerable and important principles should be applied to the contemporary context, and what all of that is going to mean going forward. And so this is an opportunity to re-engage with some of these principles and norms, to undergird them. And I think the more that we reinforce these principles and the application of these principles, it sets the stage for continued or maintained peace down the road. And ultimately, the goal of accountability, once we end the hostilities here, is to help put in place a system that is going to increase the likelihood that peace will be maintained going forward to all of those other states that are concerned, as you note, to Russian adventurism or here worse.
Right. Well, thank you so much for your time today. It was certainly enlightening, and for many people who have no experience with respect to the law of war or war crimes in general. And so for those of you who have attended and are requesting CLE credit for your attendance, be on the lookout for an email that will be sent from the CMBA. It will contain a survey of the presentation, and you'll be able to get your CLE credits once you fill that survey out. But before we go, I want to give a huge thank you again to Professors Finnegan and McDaniel for your time today and for a fantastic presentation. Thank you.
Thank you. I very much enjoyed it. Thanks for the opportunity.
Thank you.